them in, when did you last hear from them? Are you a part of the decisions they make for you?
If you take them to Luzira, they're going to continue doing the thing in Luzira.
Part of their revenues would be set aside to run an integration process.
Our Parliament, bringing the debates closer to you. The Anti-Money Laundering Act took a very long process to get passed by Parliament. It was first introduced in 2005 by the then Minister of Finance. Parliament started to actively process this law in 2009, and it was finally passed in August of 2013, getting presidential assent on the 2nd of October 2013. But from the passage of this law, how many Ugandans actually know that we have an anti-money laundering law? How many Ugandans even know what this law is about? Those are some of the things that we discuss on the show today. I'm Iguma Gabriel, your host. Welcome to our Parliament. To give us a better understanding of the Anti-Money Laundering Act, we have Sydney Asubo, the Director of Legal Affairs from the Office of the Inspector General of Government. We have Chirunda Robert, a lecturer of law with the School of Law of Makerere University. Gentlemen, welcome to our Parliament. The studio audience, it's very good to have you here and you watching at home. This show is meant to make you understand what is discussed in Parliament, so that if your MP is not doing what you expect them to do, you can actually put them to task. Let's talk about the Anti-Money Laundering Act. Sydney,
yes.
Broadly, what is this act about?
Well, it is in one paragraph it will be to combat money laundering. Now, first you need to know what money laundering is. Money laundering is it's a process of making dirty money clean. That's the best way to describe it.
What's dirty money?
Dirty money is any money that is got through criminal enterprise or through illegal means. Now, if the process of trying to make that money look clean, as though it is derived through legitimate means, is what is called money laundering. Okay. And a distinction is that it is a crime that is distinct from the crime that generates the proceeds. If, for example, you have stolen money from public coffers, and then you want to make that money look like you got it from legitimate means, maybe private legitimate means. So that process of trying to convert it is what is money laundering.
Give an example of how it is done.
A good example I always give is maybe you are a government official, and then you embezzle funds that are entrusted in your hands. Maybe you have embezzled, say, 1 billion Uganda shillings. And then you also have a company that you run. Maybe you're running a hotel business. It's a private limited company where, say, you're the majority shareholder. Now, because maybe the hotel has, say, 100 rooms, and the proper assessment shows that maybe in a given day, a month, you may have, let's take a day, maybe you have occupancy of 30 of the 100 rooms. But then you declare that on any given day, you have room occupancy of, say, 90. Meaning, therefore, that in your declaration, you are showing that there were 90 rooms that were occupied in a given night, whereas the true figure should be 30. Now, the money that you have stolen, maybe when you're going to bank this money, you'll bank money in your company accounts showing that 90 people occupied your rooms in a day. The difference, that is the 60, the money paid, that should have been paid up for the 60 extra rooms. You now get it from a portion maybe of the 1 billion.
From the 1 billion.
From 1 billion. You keep it somewhere else. So you keep it maybe somewhere else. So you bring, then you put it. Now your business records will show that you 90 rooms were occupied, and that's why you took money. So when somebody looks at these books, will show as if on the face of it, everything is okay. So these 60 rooms is what you are using as a means to disguise the money. So
clean the dirty 1 billion shillings.
The dirty 1 billion you stole from government coffers. Now, that if those facts were proven in a court of law, it will constitute the offense called money laundering.
Okay.
Yes.
Now, that law.
Yeah.
Did we pass a good law? Did Parliament pass a good law for Uganda?
Yes, it did. Now, the context in which I say that is that globally there is a group called the Financial Action Task Force. The Financial Action Task Force, we call it FATF, is a global government public body that to which it was formed initially by the G8, G7, then G8. Then so it is the internationally recognized body, and it sets up. It has recommendations. Initially there were 40 recommendations, and then after the attack on New York and in America, the twin
October 9th.
So they added 9 special recommendations dealing specifically with terrorism. Now the two go hand in hand. You should not delink money laundering from anti-terrorism financing. So the under FATF, so they are, but now since February 2002 they have made them 40. They're now 40. There have been some revisions, so they are now back to 40 recommendations. Now, any country that is a member of FATF, or maybe I should say this first, under FATF there are what you call FATF-style regional bodies, FSRBs. Now, Uganda belongs to an FSRB called the Eastern and Southern Africa Anti-Money Laundering Group. And all the FSRBs are associate members, actually are full members of FATF. So it's a requirement that if you are a member of FATF or one of the FATF-style bodies, in this case the SMLAG, you must have a legal framework that complies with the 40 recommendations. And there is also a model legislation issued by FATF on how countries should have national laws. So the Act complies with the recommendations. Now, there's also a process, because once you have enacted your law, you're supposed to, because it's I don't want to call it a peer review, but among other things, when you're a member of this, we check each other's backs, So you submit your laws for assessment to see whether they comply with the requirements of FATF. Now, Uganda's law has gone through that process. I'm happy to say that we are almost compliant with all the requirements of FATF.
Okay.
And these laws are almost the same in all across all. It's just there are differences in the penalties and the rest, but the substance of all the laws is the same.
All right, let's bring Robert in. Did we pass a good law, in your opinion?
The law, I agree with Sydney. The law has its strong points. When you look at money laundering on the international scene, we complied with the recommendations, as he points out. Secondly, and very, very importantly, is that you have other conventions, the Convention Against Corruption and so on, and we have our international obligations that came in. However, there are two main things that I find that the law could have been better at. One is that every time a country passes a law, and this is not just about money laundering, there's always the need, I believe, to domesticate the needs, to pay more attention to the more critical needs. Internationally, money laundering has had a history of focusing on, or anti-money laundering legislation has focused on the need to deal with tax evasion, the need, and then subsequently terrorist financing, and after the 2009 financial crisis, the integrity of the financial system. Our biggest problem in Uganda is not the integrity of the financial system. It will affect us, yes, it does affect us, but our biggest problem is corruption. And you will find hardly any reference in this particular act to corruption. What though the act does that then makes it in some respects a good law with regard to the various legislation that Sydney and his colleagues at the IGG's office, I think, which is the foremost office in fighting corruption, will find very useful, is that there's the question of predicate offenses. So you will find every time you're dealing with money laundering, it is not too far from other offenses. Tax evasion, for example. Corruption is another. You need not be convicted for corruption to be convicted for money laundering.
Mm.
If it was the other way around, we would have a problem.
Okay.
Now, in this particular case, that goes a long way in assisting us, especially, I believe there is a provision for mutual enforcement with regard to the mainframe anti-corruption regime. But there are certain other provisions on mutual legal assistance, for instance, which basically is the cooperation among countries. The areas I have trouble with are mutual legal assistance, jurisdictional exclusivity, and the role of judgment. In this particular law, a judgment from another jurisdiction will serve as evidentiary value. I would have preferred a framework that said if a judgment is passed in a country that is part of, say, the New York Convention on the enforcement of judgments, it would just be enforced here. I will give you an example. The Musumba case, for instance, Honorable Salam Musumba goes to India.
This is Musumba who was arrested or detained in India for some time, yes.
Honorable Salam Musumba goes, not Salam, Isaac Musumba. I beg your pardon. Honorable Isaac Musumba goes to India. His explanation to the people of this country is that he had instructions from a client, and we know that he's a qualified attorney. When he gets there, he gets himself into a bit of an issue. If he had succeeded in the commercial dispute that took him there and obtained judgment against his clients there, and his clients had assets here, all you'd have had to do was to register that judgment at the High Court and enforce it. The registration process does not open evidentiary issues. The way this law is written, I fear that we will find ourselves in a place where if a judgment is handed down in India, or another country for that matter, you're going to come here and open it up to procedural issues, and any number of things can happen.
Okay. I know I have two lawyers on the panel today, and so I do not want you to get lost in the legal gymnastics. So, very simply, this law, when it was being proposed, when Ugandans were being told that it's a good law for the country, it was pushed as a law that will fight corruption. In the way it was passed, is this law actually going to be our solution to corruption that's really eating up our society?
I think the answer to that depends entirely on the way the law is enforced. The law has its provisions that if properly enforced, and by properly I don't just mean procedurally, I mean evenly enforced, without being abused in any way or selectively applied. And I know those questions are debatable, but if the law is enforced the way any other law would be enforced in this country, then I believe it will have a certain contribution. But understand that the fight about corruption, in my view, is not too much about the number of statutes you have, but about the enforcement mechanisms. We have seen situations where my good friend Sydney has, put up a very good fight, a spirited fight. He is one of the people I can say has had a steady record in that area. And the issue there has never been the law. The issue there has always been procedural issues. One advantage I think this will bring is because it puts in place a framework for evidence gathering that has not existed before. You have the requirement on accountable persons, banks, lawyers, accountants, auditors, notaries public, directors of companies. Previously, many laws would say a company, or would just say any individual. But this one says directors.
It's very particular.
So even if you purport to resign and say, I have resigned as a director, they will come after you. So if the framework that the law creates is properly utilized, I think we will see major strides in the fight against corruption.
Okay. Sydney, is this the savior you've been waiting for in order to prosecute corruption cases?
Just to clarify one or two things from what Robert has submitted. One, is true that corruption is not so much dwelt on in this as a word in this act, but one of the core things about money laundering is that it's an offense distinct from the predicate offense. Now, the predicate offense is the one from which
the money was gotten.
Yes, the proceeds that you are trying to launder. That's why it's called money laundering. Now, there are two approaches countries can take. There are two recommendations. One is what we call the list approach. You list all the offenses that will form predicate offenses.
Sydney, can we go for a break right now and you'll explain those two procedures when we come back, all right?
Okay.
All right. We take a short break right now, but continue watching our parliament. During this break, you will see some of the stations that play this program for radio. So look at the station that's near you and listen to our parliament on radio as well.